Hi, good day. Welcome. Today we are talking about something that many people seem to have concerns with, and that is the overregulation of local government. Maybe the laws are too strict, or the regulations don't make sense, or there are so many regulations. You might have read recently that National Treasury released a report that says that heads of departments in government have to write over 240 reports just for compliance. I don't know how much it is in local government, but it probably isn't any less if you consider that many accounting officers also have to sign contracts. It is a highly regulated environment, and we are extremely fortunate to have again Jaap Visser, who will be in conversation with Johan Mettler, who is the city manager of the city of Tshwane and knows the regulations inside out, and Kirtley Stevens, who is a PhD graduate who has looked at the overregulation of local government. So we are well set to have a fantastic conversation. Over to you, Jaap.
Thank you very much, Ashraf, and thanks for the privilege of allowing me to co-host this podcast. I'm very excited about it and also about the topic, which has been on our radar for quite some time here at the Dullah Omar Institute, with various publications on the issue, and also at some point us through my predecessor, Professor Nico Steytler, coining the phrase, the strangulation of local government through regulation. And it's very exciting to be able to speak about that with Johan Mettler and also with Dr. Kirtley Stevens, who dedicated his doctoral studies to that topic. There's very few people better placed to discuss this than the two guests. So what we will do is examine the overload of laws on local government. How does it manifest, and what are the root causes for it, and what are some of the things that can be done? Also with a view to the local government white paper review that's taking place, and is this not the right time to intervene in that problem? So let's start off with just getting a bit of an understanding. What do we mean with the legislative slew, the overregulation, the strangulation of local government? How did we get from a fairly well-designed, well-developed legal framework for local government over the years into, I think, a forest of legislation, regulations, circulars across various disciplines, various sectors, that's now really over-regulating local government? How did we get there? Can you maybe give us a few examples or ideas on why did we end up in this situation? And I'm going to first turn to Johan for maybe his insights on that. Johan?
Okay. Yeah, and colleagues, in order to understand where this all comes from, one has to go and look at where local government has started. Not this local government, but the system prior to democracy. It was the lowest tier of government. So it was already a regulated space, and it was regulated by the 4 provinces then, as well as the national government. We had provincial legislation that basically prescribed every process that could happen in local government. And then on top of that, there would be then the kind of content in terms of the services that would be regulated by national legislation, whether it's water or electricity or refuse removal, fire brigade services, libraries, and so it was very much focused on execution and not really a lot to do with interpretation. So you basically just do as you were told, and you reported in that respect. Along comes the Constitution and says that local government is a sphere of government in its own right, and that the Constitution now gives it original powers, certainly legislative powers, in terms of the matters that were set out in Parts B of Schedules 4 and 5. And that was a fundamental shift. And it really took local government a while to get used to this idea that our bylaws do not have to follow what the provincial legislation would prescribe. But yet, in the beginning, it was fairly straightforward because that's what we did. We looked at the provincial legislation, and there was a process then of rationalizing the provincial legislation as the local government started to develop its own bylaws. But the overarching regulation still persisted. To make a long story short, the densification really arose, in my view, as a result of the national attitudes that would possibly prevail that said that one must still prescribe. So you often would get local government practitioners say, no, we can't do this because there's no legal basis. They always would go look for the legal basis. And then the national government latched onto that, and suddenly there were regulations that would then fill a particular gap. I would think of HR regulations, for example. There are a slew of them. If you were to print it out, you'd probably come to 1,000 pages just on HR. Yet HR is really the core of what should be your own discretion at the local level. So there were regulations coming out, circulars that would come out that would also tell you how to do your job, as well as guidelines. And then there were reporting, now also reporting regulations from all of the service departments that would come into play. And it would become a real mess of navigating through that, also trying to get your job done. Yeah?
Yeah, thanks, Johan. It just reminds me of a point that somebody once made, a very simple point, that if you look at let's say the overall organogram of the state, you have national government departments, you have provincial government departments, and then you have the municipality. A provincial department would work within one sector and would respond to one sector department at national level and work with a limited number of laws. But local government sits under that umbrella of all the national departments. Virtually all of them have some linkage with local government, and a slew of provincial department, all of them raining down on one municipality that has to comply with that entire spectrum of interest from across the entire government. So let's bring in Dr. Kirtley Stevens. So he has done his PhD here at the Dullah Omar Institute on overregulation, and had, I suppose, the time and space to take a step back and look at this from a scholarly and academic point of view. Kirtley, if you also, from your perspective and also your comparative knowledge, what would you say are the root causes for overregulation in South Africa, but also perhaps from your knowledge of systems and practices abroad?
Thanks, Prof. So the first, just to touch on Johan's point. So linking back to our historical past when local government was still a creature of statute, it seems there's a number of theories that relate to the causes why we are currently seeing this inflation of regulation and legislation impacting the local government. The one key theory is that government is very much part dependent. Like the past, where local government was strictly regulated, it seems that national hasn't really rid itself of our past, where it no longer should view local government as a creature of statute, but as a constitutional being, as a sphere of government in its own right. So we are very much still part dependent, still holding on to our past, where local government is still a creature of statute. So that still seems to persist. The second root cause for this increase of legislation is that if you go through the Systems Act, you go through all the legislation that currently is applicable to local government, the MFMA, Structures Act, you will find in none of those pieces of legislation, you will have an internal review clause, which basically states that after 6 years, then this piece of legislation should be subjected to regulation or should be reviewed by Parliament or by the relevant government department. So if you look at the MFMA, it came into operation in 2003. Up until now, that act was not yet reviewed comprehensively. So the one argument is that is lack of review. So our system, our law doesn't recognize that after a set period, the law needs to be reviewed. Hence, we are seeing the increased rate of legislation. The root cause also is government departments basically working in silos, pursuing their own self-interest. And hence, we are seeing duplicative, contradictory forms of regulation as well, impacting on local government, causing confusion. The other phenomenon or theory behind the increase of regulation is also where we are seeing this hero complex coming from national government departments, particularly COPTA and National Treasury. So, for example, if there's a problem in local government solution, again, part dependent, they will reach for the regulatory tool, they will enact a law to deal with the particular problem, although the problem is not widespread throughout the sector. The response would be, let's make another law to deal with the problem. So this is trying to display a hero complex. We want to save local government from the crisis facing local government. So these are some of the causes that is behind the increase of regulation. Thanks, Jaap.
Thanks, Gertie. Just latching on to the issue of the sectoral overlaps, because you mentioned the duplicative regulatory efforts of various sector departments. Maybe delving into the issue a bit more just to get clarity on what we mean with overregulation, because the difficulty with overregulation is that it can also be, and sometimes hold out as an excuse by municipalities for non-performance. And that's one dimension. And another dimension is that if you look at the various initiatives in isolation, none of them are ill-intended. They are all passed with the best intention. And if you look at that one particular provision or that one particular regulation, you would probably say, well, that makes sense. There's a rational thought behind it. We're trying to solve a problem. Why do we call this overregulation? But I suppose it is the cumulative effects and the duplicative legislative efforts of various sector departments that come into play. Just turning to Johan, would you be able to share one or two examples of how different departmental laws, environment, labor, energy, transport, how they overlap and intersect with the local government mandate and what kind of problems that would result into?
Okay. Look, there is, if you look at how services can be delivered, there is the Chapter 8 of the Systems Act that will tell you that you can either do something internally, like a department, or you can do it externally by means of either establishing a municipal entity or a private, or you can contract either private contractor to deliver whatever it is, water or bus services or whatever the case may be. So you have that. And the most time-consuming and difficult route to go is, of course, to decide, okay, it will be, we think that we need to examine how to deliver, let's say, electricity through a standalone entity, so that there's its own board and its CEO and so on, but it's an entity that belongs to the municipality. So now you have that. Now to get there in itself, that is an absolute dental operation. And it takes a long time. But leave that aside. You also have the municipal council that has the legislative authority to set tariffs. So now you have the council that says we can set tariffs, but it also has this entity that would now, although it is a separate entity, it does not have the authority to set its tariffs. Its tariffs are being set by the municipality because the constitution and the legislation says that is a legislative act, the act to set tariffs. So you can see that needs to be very slick alignment between what the board wants to do and what the municipality wants to achieve through its tariff. Now that in itself is also a minefield. Take it a step further. The entity would have its authority to go and communicate with its clients to go and collect money. But the municipality has exactly the same responsibility in respect of other services, for water, for refuse removal, also to communicate, also to, so you find yourself in and of course you have to comply with regulatory requirements, both as a municipality and as an entity in respect of, let's say, the quality of electricity or water that it is that you are providing. There are safety requirements that would bind both the municipality and the entity for that purpose. So you do find that within that system, there is ample room for the municipality and for the entity, for the CEO and the not to agree. Or if they do report to exactly the same institution, the department of, that there can be disjuncture in what they report, or there can be just disjuncture in what they report to the AG, both as a service authority and then as a service provider. So it created a very complex set of arrangements within a municipality, so much so that many municipalities simply decide not to go the entity route or to go the public-private partnership route because it's simply just too difficult. It really becomes unmanageable now.
Curtly, do you perhaps have any observations on this question?
Yeah. So, Prof, I agree with you on this issue. So, just another example, perhaps. So, if you look at the disciplinary rules and procedures that applies to municipal managers. So, just to demonstrate that overregulation, particularly in the form of in coordination regulatory arrangements where there's conflicts between two laws, it has real consequences. For example, I came across a number of court cases whereby a municipal manager, there's clear evidence that the municipal manager is guilty of misconduct. However, when the municipal manager was charged with the offense, the was charged under the incorrect set of regulations. Right? So you have the financial misconduct regulations, and then you that which is National Treasury's regulation, and then you have COCTA's regulations that deals with misconduct in a general sense. Now, in this particular case, the was charged under the incorrect set of regulations, and he simply walks free. So just to demonstrate that this thing of overregulation has real consequences. The other example as well, when it comes to overregulation and its consequences, is particularly relating it to Johan's point when it comes to PPPs. So, for example, if you want to venture into a PPP in the water sector, then you must not only comply with Section 76, Section 78 of the Municipal Systems Act, but you must in addition comply with the MFMA, including its PPP regulations, but in addition to that, in terms of the Water Services Act. Now, in the Water Services Act, it states that if you want to externalize a municipal service, then you need to give priority to a public entity. But the MFMA and the Systems Act regulations and laws provide the opposite. It's not that you prioritize the public entity, right? So there you see already there's a conflict between departments pursuing their own interests. And this caused a great deal of confusion. And hence, as of 2024, if you look at how many municipalities have successfully concluded a PPP, only 4 have concluded there's only 4 successful concluded PPPs at the municipal level. That just demonstrates that this thing is just not something that we are sucking out of our tongue. It has real consequences. So yeah, thanks, Jaap.
No, very interesting, Curtly. So this overregulation has real consequences, and we need to start thinking of solutions. And I want to go in that direction. But first, maybe get a bit more clarity on what is the impact of this. We've already noted that sometimes a bona fide court case or a bona fide disciplinary charge goes sour because you happen to cite the wrong regulation, or you charge in terms of the wrong regulation. And why is it really necessary to have 2-3 different sets of regulations emanating from 2 different departments dealing with the exact same problem? It really is beyond me. It really is a case where national government should coordinate itself better. So that's one clear impact. And I think what you also mentioned is the impact on public-private partnerships, which maybe one can extrapolate to municipal officials. Do not dare to be creative because there's too much risk involved. Johan, do these two types of impacts resonate with what in practice? And what other kind of impacts do you see of the overregulation phenomenon?
What you would see is a conservatism that would creep in. Like you say, you're not going to be adventurous. Perhaps be innovative is probably more correct. And that is simply because of the fear of non-compliance. So non-compliance in itself would then force, or the fear of non-compliance would then force municipal officials into a space that they are familiar with. And that really is highly problematic because circumstances change. There may be a good reason why a particular service delivery mechanism was appropriate, but now things have changed. But to get to, for example, public-private partnership is just simply too risky. Too many things can go wrong. Now you add that risk of non-compliance, so the AG is involved. You also get the added threat of disciplinary action being taken against you, especially if you're a senior manager. That process, of course, have been politicized in the sense that it is the council that must now decide, is there a prima facie case? And then it's a council that decides we shall continue with this case. Now, the original intent was that it must go to council because it's a public process, it's more transparency and the like. And it can't just be that the mayor would decide that this particular transgression is now so great that it deserves disciplinary action. No. Then the consequence of this was that it became a political decision, and the political decisions are also taken at caucus level, where there would be a decision to go after someone irrespective. So there are many reasons that would then present itself that would nudge an official not to go a particular route unless somebody can guarantee that there wouldn't be irregular expenditure, that you won't be held accountable if things were to go not as you have planned. Yeah, that for me would be a consequence of this kind of contradictory or complicated legislation.
Thanks, Johan. So we identify the governance and service delivery failures that can result from this, the fear of reprisals or the fear of non-compliance, and you're no longer innovative or adventurous. There's the weaponization of regulation. And perhaps what can also be added to that is actually, in the end, the overregulation results in lawlessness. The more law you throw at local government, the more lawlessness you create, because at some point also officials decide to simply give up and just go try to do it their own way and not adhere to regulations because it's simply too overwhelming. And you get at risk of creating a level of lawlessness, even though what you intend is the exact opposite. Does that make sense, Johan?
Yes, no, absolutely, that makes sense. For example, in the appointment regulations, there are many time frames. And I was in the council meetings where they literally had a calendar and started counting the days in order to find just one day that you are out so that we can set aside this entire process. So it becomes as pedantic as that. So the threat of it being weaponized is greater the more particular regulations are. So the regulations will not give you any discretion. It gives you a maximum period, for example, and no matter what happens, you can't exceed that. I was in a situation where we had to restart the process thrice because there was a change of government, and the regulation said that it's the same panel that must sit. So one panel can't inherit the work of another one, which probably makes sense, but it also goes to show that circumstances can change to such an extent that one must start thinking. But if a coalition agreement, or a coalition government rather, can come into play at any stage, perhaps there must be a cutoff as to whether politicians must, for example, play a role in their panel because of the risks of changes, and then one would have to restart because you simply cannot go the same. The same process cannot be followed without that kind of interruption. Yeah.
Yeah, that's very disconcerting because in the end, the well-intended legislation ends up becoming a tripwire, and the entire sector is then littered with tripwires over which the official keeps stumbling and falling and perhaps even perishing in terms of his or her involvement or career in the sector. And I think it's starting to scare off a lot of competent professionals who simply don't have the appetite to be working in this sector. And I think that could be another impact that we can note of this. So turning towards solutions, so what can be done? Curtly, what ideas would you suggest? Should South Africa consider a big overhaul of the legislation? Do we need one local government code where everything comes together? Or are there other sort of mechanisms to start addressing this problem? And what would be needed for it? Politically, institutionally, convinced you would have paid attention to this in your doctoral research. So we're very keen to hear what your suggestions are.
Yeah, thanks, Jaap. So just on the solutions and the way forward as to how we can address this. So in as much as government officials, practitioners at the municipal level, provincial and national level, all to some extent agree that there is indeed overregulation, there's also some type of disagreement between certain departments and entities. For example, FAPTA recognizes that there are simply too many laws, that there are simply too many reports, but National Treasury, on the other hand, don't see anything wrong with the MFMA or the reporting system or the number of reports that municipalities must comply with. So for us to move forward is that, firstly, there needs to be an agreement on the problem. And I think that's one of the main reasons why the earlier initiatives aimed at addressing this problem have collapsed and failed. So that's the first thing. That's the start. We need to all come on the same page and agree that this is a problem. Quite interestingly, to compare South Africa with other comparative jurisdictions, if you look at Australia, so the Australian system of local government, their system of local government, they are creatures of statutes. Right? So local government is a creature of statute. They have no constitutional autonomy or no constitutional recognition. But notwithstanding this, their governments have recognized the impact that their laws have on local government to be responsive. And that's quite an interesting comparison. So unlike South Africa, where local government has autonomy, there are certain safeguards in the constitution. The question is what prevents us from dealing with this problem? So first point of departure would be for us to agree that this is indeed a problem. Right? And while us as academics, we're in some type of agreement on the problem, government itself, within government itself, there needs to be an agreement on the problem. Then the second one, in terms of whether we need to, the first point of departure would then be for us to codify. So codify basically means that instead of having two sets of laws on the same subject matter, like in the case of misconduct or disciplining of senior managers, there's a need for us to bring these two separate set of regulations together. There's definitely room for us to do that. Right? However, with that codification process, consolidation has to take place. So consolidation is slightly different because here we will be able to identify and address anomalies in the legislation. So the first process will be to codify it, which basically is to identify certain thematic areas, to bring all the laws together and to populate it under the various policy areas. And then thereafter, we can then consolidate, right? And by fixing the anomalies in the legislation. However, for that to take place, what the early reform initiatives and the key lesson that we can take from that is that you need strong political will and you need government departments to come together. And you need an entity that is at the center that is able to drive this reform. So what the earlier initiatives, one of the primary reasons why it failed, the 2010 initiative failed, is that this initiative was primarily driven by cocktail, without any support from the presidency, without any support from National Treasury. So we need to create a strong central regulatory unit that drives this reform project. It cannot be cocktail, because cocktail cannot dictate to Treasury to change its laws, right? So you will have back and forth between departments. So you need a strong central unit supported by the presidency to drive this reform. The other option for reform also, we need a clearinghouse. Right? So that unit will serve as a clearinghouse, but we are also asking for Parliament to exercise some type of and take its oversight role over local government a bit serious in the terms of the making of regulations. As the executive, Parliament oversees the executive. And one of the executive's powers is to issue regulations in terms of the MFMA, in terms of the Systems Act. But there's no control mechanisms built into the MFMA or the Systems Act regulating how a minister issues a set of regulations. Right? So I'm saying there's ample room in the Constitution for such an oversight unit to be established within Parliament. And because this unit existed before 2014, but it no longer exists. So at the moment, there's no specific oversight into how a minister makes regulations. And in fact, and to extend it, how circulars are made. Right? And that's part of the problem. These are some of the proposals that we can use to deal with this issue.
Thanks, Kurtley. Johan, I think we really also need to reflect on some of the practical pieces of advice that you would have for officials and particularly young practitioners in the system on how to deal with this. But maybe before we go there, do you have any observations on Kurtley's suggestions or maybe additions to it?
Yes. Look, there certainly is a need to rationalize the scope of compliance is such that you cannot move without very good legal advice. Now, in the metro, we have access to that kind of capacity. But in smaller local municipalities, I would imagine the majority of district municipalities, you do not have it. So there's also a need to simplify processes or to simplify the requirements of what is needed in order to make certain decisions or in order to comply. Currently, you need a very sophisticated financial management system in order to produce financial records that would be capable of passing scrutiny at the National Treasury level. Now, that's completely understandable if you are dealing with a budget of 50-odd billion rand or somewhere in the billions. But when you are a smaller municipality, that kind of investment simply does not make sense. So the need to simplify, I think, must also be incorporated into such a process. We are not all the same. The capacity differ across the length and breadth of the country, and what is required to run a big metro cannot possibly be the same as the requirements of running a smaller local municipality. Yeah.
As you were answering that question, Johan, I was thinking it's also not right for us to just moan and groan about national government. Surely there must also be some positive signs. Have you come across any sort of nuggets of experimentation or promising initiatives where government is really trying to come together and solve at least some parts of this problem, even if it's not at a legislative level, maybe in terms of streamlining processes or coherence across government? Have you got any examples of that, perhaps?
Yes, no, most certainly. I can now speak for the metros. There's a unit within the National Treasury, the City Support Program. They really go out of their way to also to assist the metros in not also the hard stuff, but also what some would say the soft stuff, like leadership requirements, managing a complex environment. Now, some people call that soft. I'm telling you from experience, that's actually the very hard stuff, changing the culture of an organization. But just to come back of the nuggets, currently, for example, we are looking at the restructuring and transforming our water and sanitation services as well as our electricity services. In other words, to run it more effectively, to run it more efficiently. We are going through that process with the National Treasury, and we are also working with other metros in order for not only for the system to work, but also for the processes to work. So although it is new, and we are looking at establishing a kind of a business unit within the confines of the municipality, we are then also looking at what is required in order to make it work. What are the kind of rules, the internal rules that would need to be adopted in order to make this service delivery unit work, so that it can actually, so that we can identify the revenue that it generates and then reinvest that revenue back into the system so that we can start maintaining our assets, among others. So that is something new. That is something that I think that we can work back. We are working with the National Treasury and to an extent also the COGTA. Thank you.
Just a last question to you, Johan, before we start closing off also with Kirtley is, so I am a young practitioner entering local government. I'm excited. I've got a law degree or I've got affinity with law, and I find myself suddenly in this dense forest of regulation and hearing all of what we've just said. What would your advice be to this practitioner that wants to make a difference in local government?
My first advice to that young aspirant local government lawyer, local government practitioner, is to please retain your enthusiasm. Please retain your first motivation of entering the space. Adopt a can-do attitude. Be adventurous. Try new things, because it is only once you start doing that you can get the advice of those that have been in the system to say, although we can see your point, perhaps it's better to go about it in this way. So I would certainly encourage young practitioners to enter the space. It's critically important for there to be infusion of new ways of doing things. Precedents get outdated. There are definitely space for new precedent setting, and what is better than having a number of your peers? And that's also what is happening at the local level. There are legal practitioners as peers meeting within the district, within the province, that compare notes. And that's really the only way that one can learn and improve. Yeah, that's my view.
Thank you, Johan. Yeah, final word is for one of the young and certainly enthusiastic and passionate practitioners/academics. Kirtley, a last word for you. What would be your parting shot on the back of what we've discussed?
Yeah, thanks, Prof. Just to emphasize again, this problem, it's been not on government's agenda. There's currently a legislative review process, not the white paper, but in addition to that, separate process, the legislative review process. That process is somewhat on the brink of collapse because there's no movement when it comes to that legislative review project. But just to emphasize this point as in conclusion is that if we don't deal with overregulation of the sector, what will happen and what the literature and the scholarship has shown in other jurisdictions is that it will definitely lead to calculated non-compliance. Yes, there is currently in the system non-compliance that is calculated, but what will happen is that even the good laws, the laws that make sense, right, will be questioned, right? Where practitioners is going to start questioning the dignity of the entire system. So as a start, we need to start addressing not necessarily the overall or the entire framework, but we can start addressing the low-hanging fruits, right? And in addition to that, we need to not only focus on the symptoms of the problem, but also have a much more deeper understanding and appreciation for the cause of the problem. What is actually the cause of this problem? And start attacking the problem, the cause of the problem, as opposed to attacking the symptoms of the problem. And then in conclusion, and I hope other scholars would agree, including practitioners, what we are asking for as municipal practitioners or local government scholars, we are not arguing for the total deregulation of the entire sector. But what we are saying, as Johan indicated, we are asking for the rationalization, the simplification of the legal system, and with so doing also promoting smarter, better regulation for good governance. And not to make the process difficult, but for good governance. So we are not saying that we need to get rid of all laws. That's not what we are arguing for. Right? So we're not part of the deregulation camp, but we are trying to develop rules that are rational, that is fit for purpose, and that's an ongoing process. So at the moment, we cannot have the approach where we enact the law now, and then only 15, 20 years later, now we want to decide to review the law. And just to end off, there is a few positives. If you look at the current Public Procurement Act, right? So there is an internal bold review clause in the Act, right? But that clause is limited to 2 years after the Act coming into operation. I would suggest that maybe it had been 5 years or 10 years, then the Act should be reviewed. So at least there is attempts made by government to rely on these better regulation tools, which includes an embedded review clause to have that bold in the legislation. So there is some positives. But in the end, we are not arguing for deregulation. So thanks, yeah.
So the problem of overregulation is real. It has real consequences. It's not a figment of our imagination. It has also deep historical roots in development of local government and local government legislation. It's on government's radar, has been for a while, but there's always been a bit of a lackluster approach to it. It is urgent because it's one of the many factors that's contributing to the crisis in some of our municipalities. There are competent officials who have ideas and great scholars who have made suggestions and studies of this problem. So I think we have all the ingredients to really tackle this problem. And in the meantime, I think those same competent officials with the right leadership and the right enthusiasm and passion and appetite for comparing notes and working together can keep the lights on and keep local government working. But we do need a rationalization of local government legislation. And there's not an argument for a total free for all. It is about rationalizing and coordinating to improve local government legislation so that municipalities can perform at their best. I think that's how I would in brief summarize our discussion, which was extremely valuable, rich, and much appreciated. Johan and Kirti for participating in this. And it was my pleasure to facilitate the conversation. And I think that's where we call it today. Thank you very much.
Fantastic. Thank you very much, Kirti.
Yeah.
And yeah, if I may just abuse my position here, it is during the Mbeki administration where the plethora of laws and regulations came to the fore because of the project of building democracy and democratic institutions. Ironically, it was also that administration that had the concerns of the extent to which there were so many regulations and laws coming through, and called for every government department that wanted a new law to have a regulatory impact assessment. That seems to have gone nowhere. Then there was a report by the former president, Motlanthe, to Parliament on the number of laws and regulations that need to be addressed. That also went nowhere. SALGA has 10 seats in the National Council of Provinces to deal with precisely the impact of legislation on local government. That seems to have gone nowhere. So if I could give the young, enthusiastic professionals who are going to join local government, that is something that you want to become activists on, to look at why things are not happening so that we actually get to do what needs to be happening in terms of this regulatory overreach. Thank you very much. This was a fascinating conversation again, and it really just threw up a lot of ideas, which I think even the white paper could be addressing. Thank you very much.
Okay.
Take care.
Thank you
Bye-bye.
very much.